Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello, and welcome to Absolute Trust Talk. I am Jessica Colbert. I am an associate attorney at Absolute Trust Counsel. And this is a big day here at Absolute Trust Talk because I am leading today's episode. And I am joined here by, our managing attorney, Kirsten Howe, and she gets to take a little bit of a back seat today. This is our third episode in our series, AB Trusts. Do you have one? Do you need one? In our last two episodes, we've talked about what an AB trust is and why this structure is good for some families. If you missed those episodes or you need a refresher, pause this, go back and watch those. In today's episode, we're going to talk about couples who may have an AB trust and don't want it, or they don't even realize that they have it. This structure might be right for some families, but not for others. So Kirsten, why is it that we see so many new clients who have this AB trust structure and usually don't even realize that they have it until we tell them?
The thing that happened is that the law changed in 2013. Prior to that, the AB structure was pretty much the default for married couples. The estate tax exemption was very low in some of those years, down to, I think, $650,000 around the year 2000. So that, $650,000 in the year 2000 was still a lot of money, but not a huge amount. So this was kind of what we did for married couples. This was the only way that we could take advantage of both spouses' estate tax exemption. And so a lot of attorneys just did this as a matter of course, and they didn't discuss it with their clients because it was really the best thing for them.
Yes, but now there's two reasons that we don't need this structure to accomplish that anymore. The first is that the exemption amount is currently very large. It's currently $13.61 million per person. And then also, we don't need this structure in order to use both spouses' exemption amounts anymore. We now have another method called portability, where the surviving spouse is able to file an estate tax return. They claim their deceased spouse's unused exemption amount, and they can add it on to theirs. So for those reasons, we don't necessarily need the AB trust structure anymore. So now, what should people do to make sure that they do have the right structure?
First and foremost, we're always going to say, talk to your attorney. But, you can take a look at your own trust document. And especially if it was written before 2013, that's a good indicator that you probably do want to talk to your attorney and make sure this is the right thing for you. I'm just going to say that the provisions in the trust that talk about the A and B trust structure, they're very legal. It might be hard for a client to pick up their trust and read it and try and figure out what they have. So I would say, to be on the safe side, talk to your attorney, especially if your trust was written before 2013.
That's a good point. It can even be challenging for new attorneys to figure out how to read that language.
That's true. We've had a few conversations.
These are revocable trusts, which means that while you and your spouse are alive and have capacity, you are able to change them. And that's a fairly simple update to your estate planning documents.
That's right. The problem that we see, though, is when a client comes to us, a new client walks in the door that we've never met before, and this client happens to be a widow or widower and their surviving spouse. And we have to tell them that they have an AB trust. So once the first spouse dies and we have this AB trust, that is irrevocable. We cannot change it. It's irrevocable. And now this surviving spouse is stuck with this AB structure.
But you and I both know that irrevocable doesn't mean that it cannot be changed ever under any circumstances. It's just going to be harder. So what we can do is what's called a petition to modify, and we file a petition with the court. We are asking the court to modify the trust in a way that removes the requirement that the trust divide into these two subtrusts. And we have had a lot of success with these petitions.
Yeah, it's a fairly simple thing to do. When you hear the word petition in probate court, you probably are thinking about, oh, I know I'm supposed to avoid probate because that's what we say all day, every day. This is different. This is not probate. This is not that 1.5-year process that takes forever and is so frustrating and costs so much money. This is just one petition, one hearing. We point out to the judge that, we set this trust up way back in the day. Things have changed. That's the key. Things have changed and we don't need it anymore. And a probate court is a court of equity. So their focus is on doing what's right and best and fair, not on following the letter of the law, no matter what kind of distorted result we get. And so we've been able to do this for many clients. What I will say, though, is that this procedure is not for every family. Everyone in the family whose rights are going to be impacted by this procedure has an opportunity to object. And so I think you can kind of extrapolate and imagine that in a blended family where the surviving spouse has their own children and the deceased spouse has their own children, they might not all agree to this modification because it would impact the family of the deceased spouse. So we have to take a careful look at that before we jump in and start filing petitions.
That's a good point. And it's better to not rely on this as a way to fix it. It's better to, of course, address and make sure that you have the right trust that you want while you're alive and have capacity, rather than rely on this backup petition to kind of clean up the mess.
Well, right. And while you're alive, you don't need anyone else's consent. You just go ahead and it's your trust. It's revocable. Just change it. Do whatever you want. But once that first spouse dies, without everyone else's, consent, you're not going to get what you want. All right, Jessica, you did a great job.
Thank you.
First time, not for your first time. You did a great job, period. Thank you so much. It was kind of fun to sit back and just say whatever came to mind. Be the guest. I hope you all enjoyed it. I hope you got something out of it. And we very much look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.